If I am a cook and I decide that the porridge I have been asked to make for this morning has, in my assessment, issues, and I refuse to make the porridge, and as a result people go out in a unit and they are hungry and they are ambushed and they have no energy to fight, I can be charged with that offense and I can be put to death. That is if I refuse. If I don't refuse and I make the same porridge, knowing that the portion may have an issue, but we have to eat, people have to go out, it's urgent, and people go out and they develop running stomachs, I can be charged with that offense and put to death. If you do anything, if you omit to do anything. Now, Mr. Chairman, it would be useful if the court looked, while it is considering this application, looked at the rest of the paragraphs, 128(1)A to E, because they are very specific as to what it is a person could do. Disclosing by word of mouth or a document information to the enemy, that is clear. Discussing confidential information is clear. Giving a password to somebody who is not authorized, that's clear. And then at the end of that whole section, if you do anything or omit to do anything, Mr. Chairman, I contend that the offense is not defined. Article 2812 deals with the gist of it. The purpose for it is to ensure there is no vagueness. So it is the constitutional standard to deal with vagueness. And why is there a problem with vagueness is simply because you can have overreach. The application of the section depends on the whims of a person who decides that it applies or doesn't apply. The gentleman making porridge, the gentleman refusing to make porridge. If I disarmed somebody who is perhaps drunk and I assume that he is becoming a danger, and it is 6 p.m. and I have nowhere to take the weapon that I have taken from him, I maybe have to hold it up in the air shouting that, you know, I have just disarmed this person, I'm not committing an offense. There's a big problem in our assessment with that provision. So, Mr. Chairman, it is the contention of the accused person that that offense is written in words that clearly show that the people who drafted it had run out of the clarity. Then they just said, let's just also put a net and see what else we can catch. We want to catch Nile perch, but let's put a net. If we also get mukene, we get worms, we get stones, it's okay. Let's just catch everything. But the whole intention was we wanted to get Nile perch. So, Mr. Chairman, honorable members, it is our contention that there is a question that arises with regard to section 128(1)F. And the question that I will pose to the court is simply this: whether that section 128(1)F of the UPDF Act is defined in terms of and therefore consistent with Article 2812 of the Constitution. Honorable Chairman, the General Court Martial cannot answer that question because, as I said earlier, the role of answering these questions is the preserve of the Constitutional Court under Article 137(1). We trust that the Court Martial, as part of the UPDF, the law-abiding citizen institution, which is why I referred to the attributes of the force, which must be professional and disciplined, and is aware that it must subordinate itself to the provisions of the Constitution, will find this question one that can be referred for interpretation. Mr. Chairman, there is another question that we would like to also pose. And it's a question that has arisen here severally, but continues. And it is so fundamental to the trial of especially the two civilian gentlemen that it's imperative that it be addressed. It spells out the standard that is expected, that is required, from which there can be no derogation as far as a fair hearing is concerned. Fair, speedy, public hearing before an independent and impartial court. Independent and impartial. The cases, Mr. Chairman, that have dealt with the issue that I am addressing you on, the trial of civilians, are many. Captain Amon Byarugaba is one such case, 2015. Attorney General, Uganda Law Society versus Attorney General, 2005. Attorney General and Joseph Tumushabe, 2005. Michael Kabaziguruka, 2016. They have all said the same thing. And that thing is that with the setup that exists in the structure of this court, it is impossible for there to be a fair hearing. They have addressed questions of independence. They have addressed questions of impartiality. And I say this, Mr. Chairman, with all the humility I can and all the respect I can, but taking you back to the attributes of the force being subordinate to civilian authority. If the judiciary has said this is the position, then the force and its organs must subordinate themselves to that position. Because to do otherwise, Mr. Chairman, is to say that the force, that its organs, that the officers and men, the wonderful officers and men that constitute that force, can rise above the Constitution. If that route is taken, if that view is entertained, if that thought even crosses the mind of anybody, then the entire 150 words of the preamble that I spoke about are useless. We head right back into tyranny. You must distinguish yourselves from those forces that did not abide by the Constitution. And when you read Amon, Captain Amon Byarugaba, the court there was very clear. Until the apex court has pronounced itself on the interrelated issues, this is a paragraph dealing with Kabaziguruka. Michael Kabaziguruka and Attorney General, as well as ULS and Attorney General, both of which I have cited, remain good law for the present purposes. Mr. Chairman, the law now is, as interpreted by the Constitutional Court, that we can't be here to deal with civilians. Even if we want to, we can't. We can't. Unless we are elevating ourselves above the Constitution. If we are, then we can be here. But if we are not elevating ourselves, then we must abide by what those decisions say, until there is a contrary decision. There is the stay, and I'm sure my learned friend will refer to it, the stay does not remove the interpretation. Is this, whether in light of the decisions of civilian courts, both the Constitutional Court and the Supreme Court, regarding the trial of civilians in the court martial, the conduct of the General Court Martial as an organ of the UPDF to try two civilians is consistent with Article 2082, the one on being subordinate to civilian authority, 128(2), Mr. Chairman, 128(2) is that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure the effectiveness of the courts. Effectiveness of the courts includes its judgments being binding, being applicable to everybody, until there is a contrary position.